to this media engagement here at the Ministry of Information Government Complex, where today, the 3rd of December 2025, the government wishes to interact with the rest of the citizenry by way of government pronouncing itself on a few issues of national importance and national consequence. As we speak today, the most topical issue of the present moment is the Constitution and its possible amendments via Bill 7. So, that is the main issue. We are here to highlight important issues to the citizens. Let me give a brief background to where we are today and what has led us to this particular point in terms of Bill 7 and or a possible amendment of the Republican Constitution. The nation will recall that on the 23rd of November 2023, the then Member of Parliament for Petauke Central Constituency, Emmanuel J. Banda, at the behest or having been instructed by parliamentarians, both from the ruling and opposition parties, him being a member of parliament, in parliament as an independent, was tasked to write to the Honorable Madam Speaker that the members of parliament were desirous to cause constitutional amendments on matters contained in the Constitution that were hindering smooth administration of government programs at various levels of governmental administration, and therefore that those identified issues categorized as non-controversial issues needed to be brought before the floor of the House for possible amendment without expending taxpayers' money, going around doing public gatherings and consultations on issues which were dictated upon by logic, given that the members of parliament already wield a platform of representation to make laws and amend laws in accordance with the Constitution of the Republic of Zambia. A few days after Mr. Emmanuel J. Banda wrote or put in right to the Speaker a correspondence or letter that I have shared with you, dear colleagues, the media, on more than one occasion, and therefore is in public domain. Not less than 40 members of parliament of the Patriotic Front were suspended from parliament for them having absconded the presidential address of that particular year in terms of opening of parliament, in line with the precedent that was set in 2017 when parliament suspended 42 members of parliament of the UPND for absconding a similar ceremony. That therefore led to the members of parliament of the opposition, particularly our colleagues, the Patriotic Front, to hold a press briefing at which they then, in lamentation of their suspension, alleged that President Hakainde Hichilema wanted to sneak in secret constitutional amendments in order to enhance his stranglehold on power, including that he wanted to remove the running mate clause in the Constitution, that the term of office was to be amended from 5 to 7 years, and another paraphernalia of allegations contained in their press conference of that time. It is that act and that press conference contents that derailed the constitutional amendment process, which was initiated by all members of parliament who resolved, after a consultative meetings at parliament that were being held at the amphitheater. Following the collapse, therefore, of the parliamentary or members of parliament driven constitutional amendment process, on the 24th of September 2024, while addressing parliament, that is to say, opening of parliament, the President of the Republic of Zambia, President Hakainde Hichilema, did address the nation and brought the nation's attention through that presidential parliamentary address that the Republican Constitution had certain lacunae that needed attention in order to enhance the administration of national affairs. Central to the presidential revelation of those lacunae was Article 52(6), which in its current form requires that where a nomination has already been conducted and a candidate in those elections, be it at local government level, parliamentary or presidential level, withdraws, then a fresh nomination has to be conducted before those elections have to be performed. And the nation's attention was drawn to the fact that in terms of our constitution, the date of holding presidential and general elections in Zambia is cast in stone. That is to say, the Thursday of the second week of August of that particular election year. Therefore, if a candidate withdraws just before those elections, there was a possibility, particularly if it related to the presidential election, a possibility of political instability in the nation. And in order to guarantee elections that will be predictable in terms of their stability, pursuant to our national desire to maintain peace and unity in the nation, it was urged that that particular provision of the Constitution be attended to. And this is in no way, and was at that time, as it is today, in no way meant to enhance or give political advantage to President Hakainde Hichilema. Quite to the contrary, this is pursuant to what a good law should be, that a good law should be predictable, so that before an occurrence that may require legal intervention comes into play, citizens know beforehand the likely outcome. As things stand now, if we go to the general elections of 2026 with Article 52(6) in its current form, and a candidate withdraws, like we saw for Lusaka Central in 2021, a candidate withdrew and there was a fresh nomination. The only good thing is that that candidate withdrew while there's still time for the Electoral Commission to redo the ballot papers. Now, if such withdrawal of candidature were to be at presidential level, as we stand now, there is possibility to plunge the country into a constitutional crisis. Because if there may be a requirement to redo the ballot papers to exclude that candidate who has withdrawn, time might not be sufficient to ensure that that particular presidential election is held on this Thursday of the second week of August of 2026. So that is really the crux of the matter. And so those who are saying the amendment of the Constitution is not opportune, is coming at a very late hour, let's do it after the election. The question is, with this stark reality of a possibility of political instability and constitutional crisis that might be caused by a withdrawal of a candidate at presidential level, how do we attend to that issue, since we still have ample time to address that particular issue? So those are the issues we must be addressing this particular constitutional amendment, and not merely politicizing it and taking it like any other constitutional amendment process we've had before. The other critical issue that was raised attendant to the requirement to amend this constitution before the 2026 general election was the political turmoil that would have attended in 2015-2016 relating to the electoral petition, which only provides that, as the law stands now, that where there is an electoral petition, the court shall hear. And that gave room for what we saw happen in 2016. There is no clarity and there is no definiteness as to whether the court is just obliged to hear the petition and render judgment 7 months later or 2 years later. So there is an urgent requirement that such kind of a provision which is amenable to a variety of interpretations can be abused, and if so, can lead to uncertainty in our legal regime, as we saw in 2016, where to date it is on record that then the main opposition, UPND, felt robbed because the 14 days that the Constitution allocates for the matter to be heard is not defined, whether it includes weekends. Hence, the court on a particular Friday ordered that the matter will begin to be heard on Monday, only for the court that proceeding Monday to come and say the matter has collapsed because of the 14 days. Now, those are issues which presently, if we look at the way treatment was given to the interpretation of the law today, that stands to be an advantage to the incumbent president. Article 52(6) today stands as an advantage to a sitting president. The provision of the law relating to a presidential petition, the way it is now, lacking clarity and not defined and cast in stone to be predictable, is an advantage to the sitting president. So those who are alleging that this Bill 7 amendment is meant to strengthen President Hakainde Hichilema and give him political advantage should have an introspection of themselves, that there are matters we must joke around as citizens, and there are matters we must take serious because they border on national security if left unattended to, such as these two issues I've highlighted, that stand firm in terms of either holding the credibility and integrity of our elections or not. So, usual and mere political discourse, which is encouraged by our Constitution, should not overlap into issues that hold the nation steadfast as a going concern going forward. So those who are alleging that this is not opportune moment, we invite them to have an introspection on these two serious matters. If they would like to go into 2026 general election with a possibility that a candidate at presidential level may withdraw 2 weeks before those elections and plunge the nation into a constitutional and political crisis. Secondly, that in an event of a presidential petition, if they are desirous that the court should just hear a matter and shelve it and render ruling after 4 years. These are serious matters that require that those who hold themselves to have an opinion to which others may be influenced should take serious and not do politics as usual. For President Hakainde Hichilema and his administration, and therefore government, with a mandate to govern this country emanating out of an unquestionable electoral victory, we shall not relent to do the right things for our country. Notwithstanding that these particular critical provisions may, if you had an abusive leadership, be taken to be an advantage, we are here to promote genuine democracy and the growth of the rule of law and a stable political environment in our country that should provide a platform for development, national development, intended to uplift the livelihoods of our people. That is what we are here for, and that is why we are determined to ensure that we do the right things for our country. Let me therefore proceed that with that presidential address and with many well-meaning Zambians realizing that this particular constitution, which was hurriedly passed in 2016, and I'm using the word hurriedly to mean that the bill which was before the House was not the one which was passed. Because the one which was before the House, to which I was chairing as chairman for legal then, was shelved, and another introduced, and through the arrogance of numbers, it was passed. Hence these lacunae that we are now seeing, because that particular bill was never interrogated by the Select Committee of Mr. Speaker in 2016. Now, that having been said, from 2024 September, debate had been raging in the nation over these nagging questions relating to the desire of many to perfect the Constitution and the grand norm of our country ahead of the 2026 general elections in order to enhance the credibility and integrity of those elections as a foundation for normalcy and peace in the country. And those concerns raised by the citizens culminated into the executive cognizant of the fact that the citizens, even through their representatives in the National Assembly, were desirous to amend the Constitution in respect of non-controversial matters. The executive proposed constitutional amendments that were codified under the National Assembly Constitutional Amendment Bill number 7 of 2025, which was presented before the National Assembly on 26th March 2025. And that bill had the following terms of reference, because it is important to remind ourselves as citizens, because there are some people who are saying, but what is contained in Bill 7? So the following was the content of Bill 7 as it was then and as it is today. The Constitution of Zambia Amendment Bill 2025. The object of this bill is to amend the Constitution of Zambia so as to A, revise the composition of the National Assembly to provide for the increase in the numbers of constituency-based seats from the 156 to 211 to actualize the delimitation report by the Electoral Commission of Zambia. The delimitation report herein before referred to is the 2019 delimitation report, which the Electoral Commission of Zambia came up with way before the UPND took over government. But we recognize that government is a going concern. Government is not a political party. It is a going concern. And therefore, outstanding government programs, measures, and projects that get to be taken over by a new party in government have to be actualized if they are for the benefit of the citizens. And in this particular regard, they are in fact in line with, I think, Article 58, which provides that the ECZ shall conduct delimitation exercise within an interval not exceeding 10 years in order to see a possibility of increasing wards and of parliamentary constituencies because of natural increase in population, one, but secondly, as the case is, the spans or spatial coverage of those constituencies. Number 2, or B, revise the electoral system for election to the National Assembly to provide for a mixed member proportional representation electoral system to guarantee the representation of women, youth, and persons with disabilities. This is in keeping with the call by many, especially the NGOCC, that our parliament has the lowest number of women or female representation in parliament, standing I think at about just 14% out of the 156 elected members of parliament. To be specific, 17 women out of 156 elected. The NGOCC are the ones who have been pushing government to put in measures that we increase women participation, not just at levels of appointment as contained in terms of Article 259 of the Constitution, and also envisaged under Article 173 of the Constitution in terms of fair distribution of appointed members to various portfolios of governance, but in the National Assembly. So this particular provision or proposal was answering to the demand by women as led by the NGOCC. The youth, who are the majority in terms of demographics in this country, also deserve a seat and a hearing and a say in parliament, so that as decisions are made that affect them today and their future, they have a say and therefore will be held accountable and hold themselves accountable in the future in terms of posterity. The differently abled have also been recognized in terms of the current constitutional order, but that for them to see the light of day in parliament, to be members of parliament, which is highly competitive, there was need to legislate avenues through which these three categories of presently those who cannot compete equally on the political terrain should they enter parliament. That is why this provision was proposed. C. Revise the provision relating to filing of fresh nominations on resignation of a candidate. The one we have already spoken to, Article 52(6). D. Revise the provisions relating to by-elections. Again, citizens will agree that between 2011 and 2021, record can show that we have had the highest number of by-elections, the majority of which were totally unnecessary and/or uncalled for, particularly at local government level, where councillors were trading jobs to be employed in government as teachers, nurses, police officers, trading them for a seat so that the ruling party would then intend to win that proceeding by-election. And at parliamentary level, between 2011 and 2016, 38 parliamentary by-elections were held in Zambia, which is 1/4 of the entire parliament, meaning therefore that the budget, the taxpayers' money that was expended in those by-elections was actually more than 1/4 the amount spent in the general election, because a by-election is more costly because it is unplanned and ad hoc. Hence, the proposal to legislate, find a way how some by-elections can be avoided, particularly those that are avoided, such as where a councillor or an MP willfully resigns. There must be a mechanism to mitigate a cost on the taxpayer. But there are those by-elections, such as where a particular office holder dies, that it is expedient and necessary that perhaps those, a by-election could be held. That is why this proposal was brought in, to ensure that the money being expended unnecessarily in those by-elections can be redirected into developments. Because where there is a by-election, money is always found by a government to conduct those by-elections to fulfill legal requirements, yet where a clinic or a bridge or a school is required, there is no legal expedience to find money to do that. That is the requirement. That is the rationale. E. Revise the number of nominated members of parliament. This was in tandem with the fact that the number of elected members was being proposed in A to be increased to 211, and therefore proportionally that there was this proposal to also increase in a small way those to be nominated by a president. F. Harmonize the term of parliament and council to achieve a 5-year term. In 2005, the nation will recall that then Livingstone Member of Parliament on the UPND ticket, State Council Sakiba Skota, took government to court over this particular issue, that the Constitution provides that a Member of Parliament shall hold office for 5 years, but 3 months before that 5 years, a Member of Parliament is discharged of their duty. And this issue has been a talking point amongst former members of Parliament and current members of Parliament. Hence, a proposal that this also be looked into through this particular proposed amendment of the Constitution. G. Provide for a vacancy in the office of minister and provincial minister 90 days before a general election. This is simply to say, 90 days before elections, the law must be clear that there should be no one purporting to be a provincial minister or a minister, therefore using taxpayers' resources, yet they are performing campaigns, as we saw the abuse under the former administration of PF in 2011 2016, when after the dissolution of Parliament, they conferred unto themselves immunity to hand over state resources and went to campaign for themselves to come back as members of Parliament using government vehicles, government fuel, government salary, government allowances, even using state security to protect them in those elections. To propose that the Constitution should be clear on this matter, does this strengthen President HH? I don't think so. I don't think so. But that there must be clarity, because it is the law that should protect national resources. H, remove the 2-term limit for office of mayor and council chairperson. That there is a recognition that it was erroneous through the 2016 and current constitution to cap the limit of terms that a person can be elected to the office of chairperson or mayor of a council, because the same is unprecedented globally. There is nowhere in the world, there is no country where a councillor, a mayor, or a member of parliament has a term limit, because their term limit is decided by the electorates. That is why our constitution even provides for independence. But that a president is given a term limit because the president forms government through the executive, hence the need to create a limit through which governments can alternate even within the same political party. These issues we must clearly understand them as citizens, because I see a lot of uncalled for bliss when someone suggests a term limit for MPs, for instance. What is the justification? Because members of parliament sitting in that house, you know that the attrition rate this far stands at above 70%, meaning most members of parliament actually serve just for one term, except for a few. And in terms of governance, those few provide a platform for holding institutional memory, so that parliament remains a house that it is, that governs and does conduct of business of the country, not just on the basis of the standing orders and the rules of the house and of the constitution, but also the traditions of the house. That is why last time I reminded you, dear colleagues, the media, and through you, the nation, that Joe Biden, the former president of the United States of America, was a member of parliament for 48 years. Senator, which is equivalent to being member of parliament here, 48 years. And then he was vice president for 8 years. Then he was president for 4 years. Add those numbers, 60 years in national service. And there is no time when you hate them, castigate him for overstaying, because his experience was always at hand for the national interests of America. I thought we should also clarify this to buttress this particular proposal. So it was unfair that a mayor who is elected on the same ticket with a councillor and a member of parliament, these two have no term limit, but a mayor was erroneously placed a term limit, hence this proposal. I revise the composition of the council to include members of parliament holding constituency-based seats, so that they participate in the decisions of the council, including allocation of now enhanced CDF, allocation of land. These are the issues that the members of parliament who sat in 2023 at the amphitheater of parliament unanimously resolved that they are non-controversial and they needed to be effectuated in terms of constitutional amendments. I revise the qualification for appointment of the office to secretary to cabinet. Of course, this was a proposal from the executive. But these that I've given you this far are the ones that all members of parliament, as we stand today, agreed. K, provide for the Attorney General and Solicitor General to continue in office after a general election until new office bearers are appointed, to cure a situation where once a new president is appointed, even the Attorney General and the Solicitor General, who are civil servants, they vacate office, waiting for the president to appoint a new Attorney General and Solicitor General. Is this controversial? Although it was not from the MPs but from cabinet as a proposal. I, revise the definition of the words child and adult to be in tandem in the Constitution as it is in the Child Code Bill, so that we standardize also with international protocols relating to child rights. I am, provide for clarity on the period within which an election petition shall be concluded. We have spoken to this. N, provide for matters connected with or incidental to the foregoing. These are the contents of Bill number 7. The question I ask is there anything here that suggests that President HH wants to strengthen his hold on power? Is there anything here that suggests that President HH wants to remove running mate clause? He wants to change term of presidential term limit or number of years in a term? All those issues that our colleagues in the opposition, and unfortunately some who seem now to align with opposition view, are alleging are not in this particular bill. And for want of time, at another time, I will contrast this bill with Bill 10. Because there are people who are arguing that, no, but those were the contents of Bill 10. Far from it. But we've done this before, here. So let me proceed with what was the main issue which has brought us here today. Having gone through the contents of Bill number 7, it is self-evident that Bill number 7, by and large, contains non-controversial matters. Now, arising from its introduction on the floor of the House on the 26th of March 2025, a number of various reactions came through from various quarters of our society. Some commenting on Bill 7 even before they read it. It brought about national debate to a stage where President HH, as a listening president, listened to concerns and calls that Bill 7 was taken to Parliament without wider consultations and without wider participation by citizens and stakeholder interest groups. And on that score, Cabinet sat, and through a Cabinet resolution, the Minister of Justice on 26th June 2025, through Standing Order 121 of the National Assembly Standing Orders 2024, informed the Speaker in writing of the need to defer Bill number 7, which is the National Assembly Constitutional Amendment Bill number 7, in order to allow for wider consultations and wider participation by citizens and stakeholder interest groups in national constitution amendment and or making process. So, Bill 7 then was withdrawn from Parliament to allow for more input into Bill 7. Let me just bring you, dear colleagues from the media, to speed with the ramifications of Standing Order 121 of the National Assembly Standing Orders 2024, deferring or withdrawing a bill. 121.1. A member who sponsors a bill may defer or withdraw the bill at any time by formally writing to the Speaker stating his or her decision to defer or to withdraw a bill. This is what the Minister of Justice did on the 26th of June 2025. Effect of deferment or withdrawal of a bill in Parliament. 122.1. A bill that has been deferred for a period exceeding 6 months is deemed withdrawn by the member sponsoring the bill. A bill that is withdrawn shall not be presented to the House again in the same session. A bill which is substantially the same as a bill that has been withdrawn shall not be presented to the House again in the same session. Now, having withdrawn Bill 7 on 26th June 2025, President Hakainde Hichilema and his administration made known that the doors of government were wide open for all those who were concerned that their input may not have been taken on board, that they needed to come on board and speak to these proposed constitutional amendments. And from June to November 30th, there was no substantial or recognizable organization that came through to government over a round table discussion, which government had opened a window for them to speak to Bill 7 proposed amendments. And in view of that, President Hakainde Hichilema proactively set up a constitutional technical committee that went round all the 10 provinces of this country to gather views of the people, views of the citizens over these proposed amendments, to which more than 11,860 citizens participated in terms of informing Bill 7, which is the highest number in terms of citizens' participation over constitutional review processes that are on record to date. And on the 30th of November 2025, the Oasis Forum, which is a consortium of church and civil society organizations, were hosted at State House to a meeting with the President to talk about Bill number 7, its content and way forward. It was resolved at that meeting of 30th November 2025 between the government of the Republic of Zambia, the executive led by President Hakainde Hichilema, and the Oasis Forum, whose delegation leader was the NGOCC, I think CEO or chairperson, Madam Beauty Katebe, that a small working group was to be constituted to look at how to move on in terms of Bill 7 with a possibility of having a convergence of minds or consensus. The following day, 1st December 2025, the selected small working group began its work in earnest, with government represented by, led, with a team led by Attorney General Muliro Kalesha as the chief legal advisor to cabinet, who went into this small working group meeting with the Oasis Forum. And at that meeting, the Oasis Forum produced a document dated 29th November 2025, whose content was to the effect that there was no dialogue required about Bill 7. It had to be withdrawn completely, and that is to say that was their position and no other. Now look, the day before they were in a meeting with government and agreed to set a working group to resolve the differences. But when that working group came, they brought a letter which they had written before they went to meet the president and said, this is our position, no further dialogue. How is government supposed to move with dialogue with such kind of a grouping? It's a question. So government, let me place on record, government did not withdraw or pull out of dialogue negotiations over Bill 10 with the Oasis Forum. The Oasis Forum, to the contrary, are the ones who pulled out of dialogue by coming up with a precedent position to the dialogue table to say, this is our position, it's non-negotiable. Now, dialogue, we believe, is give and take. But if you come up with a position which is cast in stone, say, this is our position, then there's no dialogue. So we want the citizens to know, government did not withdraw. Government simply suspended dialogue talks with the Oasis Forum, and that is why in the wording of our correspondence to the rest of the citizens, we indicated that government has suspended dialogue discussions with the Oasis Forum for the time being, meaning the door is still open, but there was need for background work to be done, that in the event that these negotiations were to resume, we need to come as parties willing to dialogue and not those coming with fixed positions, with fixed demands. That is not the spirit of dialogue. It must also be noted here that in all this transaction, the government or the executive is not acting out of their free will and volition or whims and caprices as party in government or as a president or ministers. They have an obligation to execute, which is premised on an electoral mandate. But we are cognizant of the fact that governance of the nation involves various stakeholders. It is not just those who are elected. But we are cognizant that we have that mandate to facilitate amendment of the Constitution, and we, as the executive, are not the ones who are going to amend the Constitution. It's the other arm of government, which is the National Assembly. And it is their constitutional right in terms of Article 79 to amend the Constitution, them and them alone and nobody else. But that the rest of other stakeholders, such as the executive, can input into what Parliament is doing. So, on the same 1st of December, when the talks with Oasis Forum and government could not proceed because of the rigid position which was given in writing by Oasis Forum, demanding that Bill 7 be withdrawn. On the same day, the technical committee that had gone round the country to receive submissions from citizens did submit the technical committee report to the president for government consideration. I am here to report that following the submission of the report of the Technical Committee on the review of the Constitution of the Republic of Zambia on 1st December 2025, on 2nd December 2025, because of the enormity of importance of this matter, an urgent cabinet meeting was called, which is yesterday, to receive, deliberate, analyze, and consider the submissions of the citizens from across the country as contained in the technical committee reports. After deliberations and cognizant of the technical committee report and the attendant proposed fresh bill from the technical committee, taking also into account the views of other stakeholders, including the Oasis Forum and those who petitioned the president on 1st December, and all other various commentaries coming from various quarters of our society, cognizant of the need and acknowledging that we need to go to these elections of 2026 with a predictable law to guarantee peaceful elections. Cabinet yesterday resolved that Bill National Assembly Constitutional Amendment Bill number 7 be brought back on the floor of the House. The Minister of Justice was therefore accordingly advised to write to the Speaker so that Bill number 7 is brought back into active reality for the processes that were halted through that deferment now to roll out in the ordinary sense. Hence the announcement by the Speaker yesterday in Parliament that she was in receipt of a letter of notification from the Minister of Justice desirous to bring back Bill 7 to the House. Now, I want to clarify this and place on record that Bill number 7, which has been recalled back to the floor of the House, is the same bill. This same bill with the same contents without any alteration whatsoever. It is the same bill. It is not the proposed bill by the technical committee. And that this particular bill was recalled to the House in its original form for two main reasons. Number one, that in terms of Standing Order 122 of the National Assembly Standing Orders of 2024, you cannot introduce into Parliament a bill whose content and objects relate to a bill which is already before the House, or one which has been withdrawn from the House within that particular sitting or session of the House. So as we stand now, it is impossible at law to craft another bill to amend the Constitution of Zambia between the period remaining to subsist for this parliament to be in existence. If we have to craft another bill to amend the Constitution, it has to be after the general elections, because that is what the law says. Because within this session, this one-year period of sitting of parliament, a bill which was deferred cannot be, which was deferred and or withdrawn, cannot pave way for a fresh bill with the same objects. That is important for us as citizens to understand, because there could be people who are saying, but why are you bringing Bill 7? Why not a fresh bill from the technical committee who received fresh submissions? It cannot at law be applicable because of the position of the law. Number 2, Bill 7 has to be attended to before or about the 25th of December 2025, which period the law permits it to remain active. After that date or thereabout, this bill will be deemed, in terms of Standing Order 122, will be deemed to have been withdrawn and therefore of no consequence. Meaning, therefore, if that were to be the case, Bill 7 will not be considered by Parliament, and this proposed bill by the technical committee would also have no room to be taken to Parliament, with the ultimate or summed consequence that we will go to the general election with this same constitution, where a candidate can withdraw and cause a constitutional crisis, where a petition can be taken and the court can render ruling after 3 years. That is the reason why Bill 7 has been retained to Parliament. It is the one that the law can give life to provide a platform for constitutional amendments. Now, the report of the Technical Committee on the Constitutional Amendments and their draft bill were considered by Parliament, and Parliament, let me come through on that one. The report of the Technical Committee and the attendant proposed draft bill by the Technical Committee, which was submitted to Cabinet, were duly considered, and in light of the legal vagaries or legal challenges, it was resolved by Cabinet that those two are important sources of information for the Committee of Parliament that will be considering Bill number 7. As you all know, when a bill is taken to Parliament, various interest stakeholder groups are called, and in this particular instance, Cabinet recommended that the Technical Committee will be given an opportunity to deliver the raw material they collected from the public to an independent organ of government, Parliament, and therefore the Select Committee, to look at the possible amendment of the Constitution. That is where those recommendations that are in tandem with the objects of Bill number 7 will find breath. So, as government, therefore, we are going to adhere strictly and fervently to the provisions of the law to ensure that we do not violate any rules and regulations and laws that govern constitutional amendment that govern presentation of bills in Parliament, that govern enactment of laws. We shall follow those to the latter. It is therefore, as announced by the Speaker yesterday, that the committee looking into Bill 7 begin their work immediately, that all those who feel left out, all those who feel Bill 7 is not inclusive, if you did not speak through the technical committee, if you did not petition the President at State House, the way Oasis Forum had an opportunity to interact, and the other consortium of church and stakeholders did at State House the other day, there is now open this window at the National Assembly for all those who feel left behind to go and speak to these proposed constitutional amendments. I would like to state very clearly and categorically here that when you look at N of Bill number 7, like any other bill before Parliament, it says provide for matters connected with or incidental to the foregoing. That is to say, the matters that may be introduced in Parliament through the committee will be those matters connected to Bill number 7 and not fresh matters, unless those that are completely non-controversial, because the government, in terms of the executive, would not like to present a bill to Parliament which ends up opening a Pandora's box, where now each and everyone, all and sundry, will come up with views. Let's amend this, until it is a wholesome proposal to amend the Constitution. The government wants to stick to the initial idea as conceived and envisaged by the members of Parliament in 2023 to amend non-controversial matters of our Constitution. So, it is expected that Law Association of Zambia will be invited, NGOCC will be invited, the church will be invited, not by the executive, but by Parliament, so that they can speak to this proposed amendment as a tradition is. And I would like to indicate here that we do expect that they will come through to Parliament, because this is the tradition and standard we've set for ourselves. When we were amending the Constitution in 2026, and when there was a proposed amendment via Bill number 10 in 2021, Law Association of Zambia, NGOCC, and a number of them in the Oasis Forum were opposed to the contents of Bill number 10. Despite them being opposed, or notwithstanding, they showed up at Parliament and spoke to their opposition of Bill 10. And that is why, for those of us who are now in Parliament, as members of Parliament, who had to carry the hopes of the nation, we were strengthened because we were further informed, and we defeated Bill 10 on the floor of the House, not outside on the streets. We expect all those who participated in helping Bill 10 to be defeated to go to Parliament. If you are opposed, speak against the contents or the bill. If you support, accordingly do, so that we exhaust this channel which is provided for by our own laws to give parliamentarians an opportunity to make laws, amend the Constitution, or reject amendment of the Constitution, like we have done before in this country. Therefore, the processes of Bill 7 will be processes of an ordinary bill like it is in Parliament, and we do expect that everyone has an opportunity to come through and participate. As I conclude, let me also state here that there is something very important out there relating to this same Bill 7, which is of important comment, that a number of colleagues from Oasis Fora, the Law Association of Zambia, and 4 others, had taken this particular matter to the courts of law, seeking conservation orders that Parliament should not proceed with Bill number 7 on a number of alleged illegalities. The courts pronounced themselves to the effect that there was nothing that would stand in the way of Bill number 7. So, for that lingering question that was raised, that Bill number 7 is illegal, the courts have pronounced themselves. Hence, now, even where we are, that we have found it even more appropriate that Bill number 7 should proceed. There is no legal impediment right now to challenge Bill number 7. It is important that we come together over this matter, and we in the executive insist that these are proposals. The final document in line with these objects will be agreed upon by the citizens as they appear before the Committee of Parliament, and as that committee brings to the main house, to those who have been assigned the role to amend the Constitution, that should be the case. Some of you have also been calling me to comment on the issue of Ethel Chisomo over her conviction, 18 months conviction. I would like to indicate that for us as government, we are a law-abiding, government, and we respect the decisions of the courts and do not interfere. We have also taken note that there are many citizens who are indicating that the punishment should have been more severe given the gravity of her insolence. But the law is the law, and the courts apportion punishment in line with the theories of punishment: deterrence, reformation, retribution, prohibitive. Those are the theories, and that punishment should be proportional to the offense committed. So it is not within our province and jurisdiction to question that particular sentence. Safe to say that she has been convicted in accordance with existing laws of our land, and that as government we would like to encourage particularly young people not to abuse social media and think that you are in America or you are in wherever you think you are on this planet. The long arm of the law has a tendency and habit one day to reach out to you, and when you are caught, don't start phoning people to speak for you, to say, no, this is interference of enjoyment of human rights, this is limiting freedoms of speech, this, like I've seen on some international stage, this is going to limit freedoms of journalists. In the last 4 years, there is no journalist in Zambia who has been arrested or convicted because of a story that he or she has published. Zero. So those who have appointed up unto themselves the right to be journalists, when in fact they are not, or spokespersons of whom we don't know who has sent them. They should be ready to be held accountable, because the only way to maintain the orderliness and peace of society is to enforce the laws that do not see and are blind to who you are, your affiliation, your church, your political standing, which we have created by surrendering our individual sovereignty into a national calabash of laws to govern ourselves. So, no one should expect to violate other people's laws, to insult a president, insult other citizens, and think you get away with it because of human rights. In fact, some of these laws to do with infringement of other people's rights are more applied, more stringently in the Western jurisdictions than they are here. Yet when we apply them here, we hear voices from all over. We shall remain resolute to ensure that the law of the land applies to the latter. Dear colleagues and citizens who watched us via various media platforms, this is what your government had to share with you this morning and this afternoon. I thank you.
Thank you very much, Honorable Minister. Colleagues, if there are any questions, the Minister will take questions on points of clarification, or if at all there are any other questions in another matter. The Minister is ready to take those questions. Any questions? Any questions?
There are no questions I can see. Dear colleagues from the media, I can see you are rushing to go and do your stories. Yes. Thank you so much for coming, but we thought it was very important to clarify these issues, because you are the ones who inundate me with questions every day. So together we will be going through these things, so that when people comment out there, you can check with them as to what is the truth and what the law stands, so that they don't mislead unsuspecting citizens. Thank you for the opportunity. We'll meet again soon.